Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Alright, let's get into it. Picture this: you get that dreaded jury duty summons in the mail. You sigh, you show up, and you walk into a real American courtroom for the first time. What are you expecting? A brilliant, fast-talking lawyer in a $1,000 suit, pacing in front of the jury box. You're waiting for the dramatic opening statement, the shocking cross-examination, that moment where a surprise witness bursts through the doors and changes everything. You're waiting for someone to leap to their feet and scream, "Objection!" But instead you get hours of silence. Lawyers quietly shuffling mountains of paper. A judge who seems half asleep. And conversations so bogged down in procedural jargon it feels like they're speaking another language. You sit there thinking, is this it? Where's the drama? Where's the aha moment? Here's the secret they don't tell you. That aha moment you're waiting for already happened. 6 months ago, in a stuffy conference room with no cameras and no jury present. Here is the single most important statistic you need to know about the American legal system. Over 95% of all criminal cases, and an even higher percentage of civil cases, never go to trial. They are settled, they are dismissed, or they are resolved through plea bargains long before a jury is ever selected. Think about what that means. Almost every single courtroom drama you have ever seen, from Law and Order to Suits to Better Call Saul, is based on the 5% exception, not the rule. Hollywood has sold you a thrilling, high-stakes casino game, when the reality is a grueling strategic game of chess, where the most important moves are made in silence, long before the opening bell. And that is exactly why we're here. This isn't just about pointing out what your favorite TV shows get wrong. This is about giving you the real playbook. We are going to pull back the curtain and show you how the lawyer game is actually played and won in the United States. You'll learn the strategies, the psychology, and the unwritten rules that determine who wins and who loses. By the end of this, you won't just be able to spot the Hollywood fiction. You'll understand the real-world system in a way that can empower you, whether you're on jury duty, a C-SPAN junkie, or just someone who wants to understand the forces that shape our society. So let's start with the most famous, most abused, and most misunderstood phrase in all of legal fiction. Objection. On TV, it's a weapon. A lawyer shouts it to interrupt a damaging question, to throw the other side off their game, to show the jury that something unfair is happening. It's pure theater. A fiery lawyer objects, the other lawyer retorts, and the judge bangs the gavel with a dramatic sustained, or overruled. In a real courtroom, objecting like that is the fastest way to make the judge hate you. The reality is, objections are not about drama. They're about preservation. When a lawyer objects in a real trial, they are doing one thing, creating a record for a potential appeal. They are telling a higher court, hey, something happened down here that violated the rules, and I want you to know I was against it from the start. It's a procedural necessity, not a rhetorical flourish. Most objections are quiet, quick, and almost boring. A lawyer will often just stand up and say, "Objection, hearsay," or "Objection, relevance." There's no shouting, no pointing. Often, the judge will rule just as quietly with a simple sustained or overruled, and everything moves on in seconds. Why? Because 99% of the arguments about what evidence should and should not be allowed have already happened. They happen weeks or even months before the trial and hearings for something called a motion in limine. That's Latin for "at the start." This is where the real fight over evidence occurs. Each side files documents arguing to the judge why the other side's evidence should be excluded. Your Honor, they want to bring up my client's prior speeding ticket in this fraud case. That's irrelevant and prejudicial. It should be excluded. Your Honor, they want to introduce an email without proving who actually sent it. That lacks foundation. It should be excluded. The judge rules on all of these motions before the trial. So by the time the jury is in the box, both sides already have a clear set of rules about what questions they can ask and what evidence they can show. The dramatic, trial-stopping objection you see on TV is incredibly rare. A lawyer who is constantly objecting during a trial isn't a brilliant strategist. They're a sloppy preparer who didn't handle their business beforehand. They're annoying the judge, they're confusing the jury, and they are losing the game. This brings us to the second, and perhaps biggest lie Hollywood tells you. The myth of the surprise witness or the smoking gun evidence. You know the scene. The case is going badly. Our hero lawyer is on the ropes. Then, at the last possible second, they get a mysterious phone call. They race across town to find a secret ledger or a long-lost witness. They stride back into the courtroom and announce, "Your Honor, the prosecution calls a rebuttal witness." The doors swing open, a shocking figure walks in. The opposing lawyer's jaw hits the floor, and the case is won. That is, without a doubt, the most surefire way to get disbarred, sanctioned by the court, and sued for malpractice in the real world. That move isn't just against the rules. It fundamentally violates the entire principle of the modern American justice system. It's called trial by ambush, and it is strictly, unequivocally forbidden. The entire pretrial phase of a lawsuit, a process that can take years, is built around one central concept: discovery. The discovery process is exactly what it sounds like. It is a legally mandated, court-supervised process where each side is required to show the other side all of their evidence. Everything. You have to turn over every relevant email, every document, every photograph. You have to provide a list of every single witness you might possibly call to testify. The other side then gets to question those witnesses under oath, before the trial, in a proceeding called a deposition. Think of discovery as both sides being forced to lay all their cards on the table, face up, before the poker game even starts. There are no cards up your sleeve. There are no hidden aces. By the time you get to trial, each lawyer has seen every piece of evidence and read every word of every key witness's pre-trial testimony. So where do the real aha moments come from? They don't come from a surprise document. They come from using a document everyone has already seen to catch a witness in a lie. The real courtroom magic isn't pulling a rabbit out of a hat. It's asking a witness, "Sir, you just told this jury that you never saw the blue car, is that correct?" The witness says yes. Then the lawyer calmly walks up with a transcript of their deposition from 6 months earlier, places it in front of them and says, "Could you please read line 14 on page 87 of your sworn testimony out loud for the jury?" And the witness is forced to read their own words from 6 months ago, under oath, where they clearly stated, "I saw the blue car run the red light." That's the kill shot. There's no surprise evidence. The surprise is in the contradiction. The drama is in the preparation. The victory is in knowing the evidence, and your opponent's case, better than they do. It's not about finding a smoking gun. It's about using the opponent's own words and evidence to build a cage around them, piece by piece, until there is no room left for them to maneuver. So if the dramatic objections are a fiction, and the surprise evidence is illegal, where does the real battle happen? If over 95% of cases never even make it to a trial, what are all these lawyers doing? They are fighting a war you never see on television. A war of paper, of procedure, and of psychology. It's a war fought in depositions, in motions, and in mediation. And that is where the game is truly won or lost. So let's pull back the curtain on that hidden war. The first, and arguably most important, phase is called discovery. The name sounds simple, almost academic, like a scientific process. But don't be fooled. This is the intelligence-gathering operation of the legal world. On TV, a lawyer gets a case, does a little PI work, and then bam, they're in court pulling a surprise witness out of a hat like a magician. In reality, that's not just rare. It's illegal. The American justice system is designed to prevent what lawyers call trial by ambush. The core principle is that both sides get to see the other's cards before the game even starts. They have a right to know every fact, every witness, every piece of evidence the other side plans to use. This mandatory sharing of information is discovery. And it is a brutal, exhausting, and mind-numbingly detailed process that can last for months, or more often years. This is where the paper war begins. The first volleys are fired with weapons you've probably never heard of. They're called interrogatories and requests for production of documents. Interrogatories are simply a list of written questions that one side sends to the other, which must be answered in writing, under oath. Now this sounds boring, right? A glorified homework assignment. But a skilled lawyer doesn't ask obvious questions like, "Did you run the red light?" They craft questions that are like legal landmines. They'll ask something that seems innocuous like, "Please identify every person who has knowledge of the facts of this case." Or, "Please state every fact that supports your claim that my client was negligent." The goal isn't just to get information. It's to box the other person in. to force them to commit to a story on paper under penalty of perjury, long before they ever see a jury. Every answer they give becomes a potential trap. If they later try to change their story or bring up a new fact in court, the lawyer can stand up, hold up that piece of paper and say, "Ladies and gentlemen of the jury, a year ago under oath this person said X. Today they're telling you Y. Which is it?" It completely destroys their credibility. This isn't a dramatic courtroom confession. It's a slow, methodical dismantling of the opponent's case, one written answer at a time. Then comes the second weapon, requests for production. This is the demand for documents. All of them. In the old days, this meant boxes and boxes of paper. Today, it means terabytes of data. We're talking every email, every text message, every internal memo, every spreadsheet, every server log, every photo, every piece of electronic data that could possibly be relevant to the case. Think about your own life. How many emails have you sent in the last 5 years? How many text messages? Imagine having to turn all of them over to a hostile adversary whose only job is to pick them apart, find your mistakes, find your moments of anger or carelessness, and use them against you. This is where cases are often won. Not with a smoking gun document that mysteriously appears at trial, but by a junior lawyer at 2 in the morning, fueled by coffee and pizza, sifting through a mountain of 200,000 emails, who finds that one single forgotten message from 3 years ago. An email where a manager jokes about cutting corners on safety. A text where a spouse admits they were looking at their phone right before a car crash. The other side is legally obligated to turn this information over. The game is about knowing what to ask for, and having the endurance to find the needle in the digital haystack. This process can cost hundreds of thousands, even millions of dollars in lawyer time alone. It's a war of attrition. A bigger company can literally try to bankrupt a smaller opponent by burying them in document requests, forcing them to spend a fortune just to comply. It's a dark part of the system, but it's the reality. After the paper has been exchanged, the war moves to the conference room. This is the part that TV tries to emulate but never gets right: the deposition. A deposition is sworn testimony, given under oath, but it doesn't happen in a courtroom. There's no judge, no jury. It's just the lawyers, a court reporter transcribing everything, and the witness, the deponent. On TV, this is where the witness breaks down and confesses on camera. That almost never happens. The real goals of a deposition are far more strategic. First, it's a fishing expedition. The lawyer gets to ask any question they want that could lead to relevant evidence. It's their one chance to explore every nook and cranny of the witness's story without a judge telling them to move on. They are testing theories, looking for weaknesses. Second, and most importantly, it's about locking the witness into their testimony. Just like with written interrogatories, the lawyer wants to get the entire story on the record. That way, if the witness tries to change a single detail at trial, the lawyer has a transcript, certified by a court reporter, to impeach them. They can literally read the witness's own words back to them in front of the jury. "Mr. Smith, do you remember sitting in my office on March 15th? Do you remember swearing an oath to tell the truth? And do you remember me asking you, was the light red? And you answering, yes, it was definitely red. Is that what you said?" It's devastating. And third, it's an audition. The lawyer is sizing up the witness. How do they handle pressure? Are they likable? Do they seem trustworthy? Or do they come across as shifty and evasive? The lawyer is trying to predict how a jury will react to this person. A case that looks great on paper can fall apart if your star witness is a nervous, unlikable person who can't tell a coherent story. Conversely, a weak case can be saved by a witness who is so compelling and sympathetic that a jury will believe anything they say. After a key deposition, a lawyer will go back to their client and say, "Our witness was a disaster. They're going to kill us on the stand. We need to settle this case now." Or they'll say, "Their main witness completely fell apart. They have nothing. Let's push for trial." Imagine you're the witness in a deposition. You're in a sterile conference room. You've sworn an oath. The opposing lawyer starts asking you questions. They seem friendly, conversational. They ask about your job, your family, your background. You start to relax. Then the questions get more specific. They ask about an email you sent 4 years ago. You don't remember it clearly. You try to explain the context. The lawyer just nods. "Just answer the question, please." They ask you the same question 5 different ways. You get frustrated. You start to get angry. You lose your cool and say something you regret. And it's all on the record. The friendly lawyer wasn't your friend. They were surgically dissecting your story, testing your composure, and creating a transcript they can use to destroy you later. This is the hidden battlefield. This is where the groundwork for victory is laid. Through thousands of pages of documents and hours of sworn testimony, a lawyer builds their case, not for the trial but to avoid the trial. They are gathering the overwhelming evidence needed to walk into the other side's office and say, "Here is a mountain of proof. Here are the transcripts where your witnesses contradict themselves. Here is the email your client forgot they sent. Your case is hopeless. Settle now, or we will bury you in court." That is how over 95% of cases in the United States are resolved. They end here in the trenches of discovery, long before a single juror is ever chosen. But what about the other 5%? What about the cases that don't have a smoking gun email, the ones that survive the initial paper war? These are the cases that move on to the next phase. A phase that television has transformed into the most dramatic confrontation outside of the courtroom itself: the deposition. On screen, a deposition is a pressure cooker. It's always in a stark, intimidating room. A single witness sits at a long table, sweating under the relentless, rapid-fire questioning of a brilliant lawyer. "Isn't it true you were at the docks that night? Isn't it true you hated your boss?" The witness stammers, their own lawyer objects futilely, until finally, the brilliant lawyer slams a secret photo on the table. "Then explain this." The witness breaks, sobbing, confessing to everything. The case is won. It's pure, uncut legal drama. And it is a complete and utter fantasy. The purpose of a real deposition is not to get a confession. It is not to win the case. The purpose of a real deposition is to not be surprised. That's it. It is the single most boring, tedious, and soul-crushingly methodical process in the entire legal system. The goal is to learn everything the witness knows, to hear their entire story, and most importantly, to lock them into that story under oath so they can't change it later. A good deposition lawyer isn't looking for a knockout punch. They're meticulously collecting ammunition, one grain of gunpowder at a time, for a battle that will happen months or even years down the road. Imagine a simple car crash case. On TV, the deposition of the defendant driver would be a tense thriller. "You were texting, weren't you? Admit it." In reality, it would sound more like this. "Good morning. Please state your full name for the record. Can you describe the weather on the day of the accident? What did you have for breakfast that morning? At what point did you first get into your car? Which route did you take? Describe the traffic conditions. In the 10 minutes leading up to the collision, did you operate your cell phone in any way?" Every question is slow, deliberate, open-ended. The lawyer isn't accusing. They're exploring. They're mapping out the witness's memory. The witness, who has been prepped for hours by their own attorney, will give calm, short answers. "No, I don't believe I did." The lawyer will make a note on their legal pad and move on. "Did you adjust the radio? Did you speak to any passengers? Did you consume any beverages?" Why this agonizing detail? Because the lawyer already has the defendant's cell phone records, which they got during discovery. They know the defendant sent a text message 17 seconds before the 911 call was made. But they're not going to slam those records on the table. That's a TV move, and it's a stupid one. If you reveal your trump card now, you give the witness and their lawyer months to come up with a plausible explanation. Maybe the car has a hands-free system. Maybe a passenger sent it. Maybe the timeline is slightly off. You've shown your hand, and you've gained nothing. Instead, the lawyer lets the witness deny it under oath. They let them build the lie. So, to be clear, your phone was in your pocket untouched for the entire 10 minutes before the crash? Yes. The lawyer thanks them, and the deposition continues for another 5 grueling hours, covering every possible detail of the driver's life, car maintenance, and medical history. The gotcha moment doesn't happen in that conference room. It happens 8 months later in front of a jury. The defendant is on the witness stand, having just told the jury the same polished, rehearsed story. He was a safe driver paying full attention. Then, on cross-examination, the plaintiff's lawyer calmly walks up to the witness stand. "Sir, you just testified that you weren't using your phone. Is that correct?" "Yes, that's correct." "Your memory of that is clear?" "Crystal clear." The lawyer then turns to the judge. "Your Honor, may I approach?" The lawyer walks back to their table and picks up a thick, bound volume. It's the deposition transcript. "Sir, do you recall giving a deposition in my office on March 12th of last year? And you swore an oath to tell the truth that day, the same oath you took here today. I'd like to direct your attention, and the jury's, to page 84, Line 12 of your sworn testimony. I asked you, was your phone in your pocket untouched for the entire 10 minutes before the crash? And your answer under oath was, yes. Is that your testimony? The witness has nowhere to go. He's been caught. Not in a moment of surprise, but in a carefully constructed trap laid months before. The lawyer then pulls out the phone records. Now let's talk about the text message you sent at 2:32 p.m., 17 seconds before the accident. The witness's credibility is destroyed. The jury now sees him not as a victim of circumstance, but as a liar. That is the real power of a deposition. It's not a weapon for a single dramatic explosion. It's the slow, patient process of forging a key that will unlock the truth in front of a jury. But depositions serve another, equally vital purpose that TV ignores. They let you size up the witness. Is your star witness a nervous wreck who will crumble under the slightest pressure? Is the opposing CEO a charming, sympathetic figure the jury will love, or an arrogant monster they'll despise? A case that looks unbeatable on paper can completely fall apart if your client is fundamentally unlikable. Conversely, a legally weak case can sometimes be saved by a client who is so genuine and sympathetic that the jury desperately wants to find a way to help them. The deposition is the dress rehearsal for the trial, and smart lawyers are paying as much attention to the performance as they are to the words. So let's say your case has survived discovery. You've gone through the marathon of depositions. You've collected your ammunition and you're ready for trial. Not so fast. There's another massive hurdle. Another great filter that eliminates a huge number of cases before they ever see a courtroom. It's called the motion for summary judgment. This is perhaps the single most important legal procedure that television never ever shows. Because it's a battle fought entirely on paper. There are no witnesses, no objections, no dramatic speeches. There are just 100-page legal briefs, stacks of exhibits, and a judge reading them in their chambers, often alone. The argument in a motion for summary judgment is simple and devastating. One side essentially says to the judge, "Your Honor, even if we pretend that every single fact the other side says is 100% true, we still win based on the law. There is no genuine issue of material fact that a jury needs to decide." For example, imagine someone sues a hospital because they slipped and fell on a wet floor. The hospital's lawyers might file a motion for summary judgment. They'll attach the deposition testimony of the plaintiff, where the plaintiff admitted they saw the wet floor sign. The hospital's argument is, even if the floor was wet, and even if the plaintiff fell and was injured exactly as they claim, they've admitted they saw the warning sign. Under the law of this state, that means they assumed the risk. There's no fact for a jury to argue about. We win. Case dismissed. The plaintiff's lawyer will file a massive brief in opposition, perhaps arguing the sign wasn't visible enough, or that the law has an exception. But the fight is all about legal interpretation and undisputed facts. The judge will read both sides' arguments, look at the evidence presented, and make a decision. If the judge agrees with the hospital, they'll issue a written order that says motion for summary judgment granted. And just like that, with a click of a mouse sending an email, the case is over. No trial, no jury, no dramatic conclusion. It just ends. This is another huge part of the American legal system's design. It's a machine built to avoid trials. Trials are expensive, unpredictable, and time-consuming. Discovery, depositions, and summary judgment motions are all designed to narrow the issues and dispose of cases where the outcome is legally clear, long before you get anywhere near a jury box. So if your case has survived the paper war of discovery and the psychological chess match of depositions, if it has dodged the silent killer known as summary judgment, you finally find yourself on the courthouse steps. You're finally going to trial. But the first person you need to convince isn't the judge or the jury. It's a court clerk with a calendar, and that's a battle you might not be prepared for. That clerk, armed with a digital calendar and a well-worn telephone headset, holds more practical, day-to-day power over your case than a dozen Supreme Court justices. On TV, a lawyer like Harvey Specter or Jack McCoy decides they're going to trial, and boom, they're in a courtroom the next day delivering a searing opening statement. The reality is a slow, grinding negotiation with a judicial assistant who is juggling 500 other cases, 25 other lawyers who all think their case is the most important, and a judge who is triple booked for the next 18 months. You see, a court's calendar, its docket, isn't a simple appointment book. It's a strategic battlefield. It is the single most constrained resource in the entire legal system, and access to it is guarded fiercely. Getting a trial date is not a request, it's a plea. It's a complex dance of coordinating schedules for the judge, 2 or more opposing law firms, dozens of potential witnesses, and the availability of a physical courtroom. Your lawyer might call the clerk and say, "We're ready for trial." The clerk, without a hint of irony, might reply, "Great. The judge has a 2-week slot available in September of 2026. This is the first soul-crushing reality of litigation. The hurry up and wait phenomenon. Everything is an emergency until it isn't. You rush to file a document by a 5 p.m. deadline, only for it to sit in a digital queue for 6 months before a judge even looks at it. This delay isn't just an inconvenience. It's a weapon. A well-funded corporation being sued by an individual knows this. They can afford to wait. Their lawyers can file motion after motion, request delay after delay, knowing that every passing month drains their opponent's financial and emotional resources. They use the court's own glacial pace to bleed the other side dry, hoping they'll give up and accept a lowball settlement offer out of sheer exhaustion. This is the scheduling shuffle, a strategic use of delay that TV never ever shows. But before you even worry about a trial date years in the future, you have to survive the real war. It's not fought with surprise witnesses and dramatic objections. It's fought with paper. It's called motion practice, and it is the single most important and most untelevised aspect of winning a lawsuit. A motion is simply a formal written request asking the judge to do something, and lawyers file motions for everything. A motion to compel, when the other side won't hand over documents. A motion to exclude evidence they think is unfair. A motion for a continuance to delay a deadline. Each one of these is a mini lawsuit in itself. Your lawyer writes a document called a brief, laying out the facts and citing previous cases to argue why the judge should grant their request. The other side then files a response brief arguing the opposite. Then your lawyer might file a reply brief, responding to their response. We're talking about hundreds, sometimes thousands of pages of dense, intricate legal argument before you ever set foot in a courtroom. This paper war is where cases are often won or lost. A brilliant trial lawyer who can't write a persuasive motion is like a star quarterback who can't read a defense. They're going to get crushed before the main event even starts. The judge reads these briefs in their chambers, long before they ever see the lawyers in person. An opinion is already forming. The momentum of the case is shifting, based entirely on the strength of the arguments made on paper. And the king of all these paper battles is the motion for summary judgment. This is the legal equivalent of a knockout punch. In essence, your opponent files a motion that says, "Your Honor, even if we assume every single fact the other side claims is true, the law is so clearly on our side that there's nothing for a jury to even decide. We win. Right now. End of case." Think about that. On TV, the climax is the jury verdict. In reality, over 90% of civil cases never reach a jury. They are dismissed by a judge on a motion, or they settle. The motion for summary judgment is the gatekeeper. To defeat it, your lawyer has to show the judge that there is a genuine issue of material fact. A fancy way of saying, "Hey, there's a legitimate disagreement here that a jury needs to sort out." This is an absolutely colossal moment in any lawsuit. It can be a 100-page motion with thousands of pages of exhibits, deposition transcripts, emails, expert reports. Your lawyer will spend weeks, maybe months, crafting the perfect response. The entire fate of your case hangs on this mountain of paper. If your lawyer loses this motion, it's over. You don't get your day in court. You don't get to tell your story to a jury. The judge bangs a gavel in a nearly empty courtroom and you lose. Game over. There is no last-minute confession on the stand, no dramatic reversal. Just a quiet, anticlimactic order signed by a judge, delivered to you in an email. It is the brutal, unglamorous heart of the American legal system. If the judge feels there's a debate to be had, they won't just decide based on the paper. They'll schedule a hearing. But again, forget what you see on TV. There's no jury, no witnesses. Often, it's not even in the main courtroom. It might be in the judge's library or a small hearing room. It's just the lawyers and the judge. Each side gets maybe 15 minutes to argue their case. This is where a lawyer truly earns their money. It's a high-wire act of pure intellectual combat. The judge has read the briefs and comes armed with brutally difficult questions. They interrupt. They challenge. They play devil's advocate. They are stress-testing your lawyer's entire theory of the case in real time. A great lawyer in this setting doesn't give a speech. They have a conversation. They have to know the record, the facts, and the law so cold that they can pivot instantly, answer a question about page 874 of an exhibit, and seamlessly return to their core argument. Watching a master at work in a motion hearing is like watching a grandmaster play speed chess. It's quiet, it's intense, and the stakes are immense. A single bad answer, a moment of hesitation, can sink the entire case. This is the lawyer game. It's a grueling marathon of writing, researching, and arguing over procedural minutiae and complex legal doctrines, all while navigating the bureaucratic maze of the court calendar. It takes place over years, in quiet offices and near-empty courtrooms. The emotional and financial toll on the people involved, the clients, is devastating. Their lives are in limbo, waiting for the next brief to be filed, the next hearing to be scheduled, the next inscrutable court order to be issued. But let's say you survive. You've navigated the scheduling chaos. You've won the paper war. You've survived the judge's grilling at the motion hearing and defeated summary judgment. Against all odds, a trial date that was once a distant mirage on the horizon is now finally terrifyingly real. The war of paper and procedure is over. Now, you have to win the war of people. You have to pick 12 strangers from a crowd and convince them to see the world your way. And that is a psychological game of manipulation and perception that makes everything you've done so far look like child's play. On television, this game looks simple. A charismatic lawyer scans a room full of ordinary faces. He locks eyes with a kindly-looking grandmother, then a stern-faced accountant. With a flick of the wrist and a confident nod to the judge, he says, "We'll take jurors 2, 4, and 7, Your Honor." The defense is ready. The whole process takes about 90 seconds of screen time. That is a complete and utter fantasy. In the real world, jury selection, or as the lawyers call it, voir dire, a French term meaning to speak the truth, is one of the most grueling, high-stakes, and psychologically dense parts of any trial. It's not where you pick your friends. It's where you desperately try to get rid of your enemies before they have a chance to sink you. This isn't about selection. It's about deselection. It's a methodical hunt for the hidden landmines in the jury pool. The process begins long before anyone steps into the courtroom. A summons arrives in the mail for a few hundred citizens, compelling them to appear for jury duty. From this large pool, a smaller group, maybe 50 to 100 people, are brought into the courtroom for a specific case. These are the potential jurors, the venire panel. And the first thing that happens isn't a charming Q&A. It's paperwork. A lot of it. Many jurisdictions now use extensive, multi-page juror questionnaires. We're talking dozens, sometimes hundreds of questions designed to be a psychological strip search. What newspapers and magazines do you read? What are your favorite TV shows and websites? Have you or anyone close to you ever been the victim of a crime? Have you ever been sued? Do you have strong feelings about corporations? About the police? About doctors? Do you own guns? Do you have bumper stickers on your car, and if so, what do they say? The legal teams pore over these answers for days, armed with highlighters and red pens, building a preliminary psychological profile of every single person. They're not looking for good or bad people. They are looking for biases, both conscious and unconscious. They're looking for life experiences that will make a juror incapable of hearing the story the way they need them to. If you're a prosecutor in a drug case, the guy whose favorite show is Breaking Bad, and who lists High Times as his favorite magazine, is probably not your guy. If you're defending a corporation in a pollution lawsuit, the woman who is a monthly donor to Greenpeace and has a Save the Whales bumper sticker is a 5-alarm fire. And this is where the real money comes in. For high-stakes civil cases or major criminal trials, the legal teams don't do this alone. They bring in the secret weapon the TV shows never talk about: jury consultants. These are highly paid psychologists, sociologists, and communication experts whose entire job is to game the human element of a trial. They run focus groups, testing case themes on different demographics to see what resonates. They build sophisticated profiles of the ideal juror for their side, and the juror from hell they need to avoid at all costs. For a plaintiff injured by a faulty product, the ideal juror might be a highly empathetic, anti-authoritarian person who believes corporations put profits over people. The jury consultant will tell the lawyer to look for social workers, teachers, and artists. For the corporation being sued, the ideal juror is a logical, rule-following, fiscally conservative person who believes in personal responsibility. The consultant will say to look for engineers, accountants, and small business owners. It's a chillingly precise science of human prejudice. With these profiles in hand, the lawyers finally walk into the courtroom for the actual questioning. And the questions they ask are rarely what they seem. A good lawyer never asks a question they don't already know the answer to, and in voir dire, they never ask a question that isn't designed to do one of three things. First, to get a juror to reveal a bias they didn't admit on the questionnaire. Second, to begin subtly indoctrinating the entire panel with the themes of their case. And third, to build rapport. A bad lawyer asks, "Can you be fair and impartial?" Everyone says yes. It's a useless question. A good lawyer asks something far more insidious. Let's say you're defending someone accused of assault. You might ask the panel, "Raise your hand if you agree with the statement. Where there's smoke, there's fire." In other words, if someone is arrested and sitting here on trial, they probably did something wrong. You watch carefully who raises their hand quickly, who hesitates, who looks around to see what others are doing. You're not just listening to their answers. You're watching their body language, their interactions with their neighbors. You're trying to read the unwritten text of their soul. Then you start educating. The plaintiff's lawyer in that medical malpractice case might say, "We all respect doctors. They have years of training. But does anyone here believe that because someone is a doctor, they are incapable of making a mistake? A careless mistake that can change someone's life forever." In one question, you framed the entire case. Respect but fallibility. A good person made a terrible, life-altering error. You're planting the seeds of your story before the trial has even begun. As this interrogation unfolds, the lawyers are making a kill list. They have two weapons to remove jurors. The first is a for-cause strike. This is for someone who is openly, demonstrably biased. The juror who says, "My son is a police officer, and I'll believe his testimony over anyone else's." Or, "I was a victim of a very similar crime, and I don't think I could be fair." You have an unlimited number of these, but you have to convince the judge, and judges are reluctant to grant them. The real game is in the second weapon, the peremptory strike. Each side gets a limited number of these, maybe 6, maybe 10, depending on the case and jurisdiction. These are your silver bullets. You can use a peremptory strike to remove a juror for literally any reason you want. Or no reason at all. You just don't like the way they looked at your client. You have a bad gut feeling. They remind you of your third-grade teacher who failed you. As long as your reason isn't based on race or gender, which is illegal, you can strike them. And this is a brutal, high-stakes poker game. You have 6 chips. Do you use one on the juror who seems a little too pro-business for your injured client? Or do you save it because there are 5 more people behind him, and one of them might be the CEO of a Fortune 500 company? You watch the other side. Who are they afraid of? If the prosecutor strikes a highly educated, analytical juror, you know they're worried their evidence is weak and won't stand up to scrutiny. If your opponent strikes a blue-collar union worker, you know they're afraid of a juror who will sympathize with the little guy. You're constantly calculating, weighing probabilities. You have your list of jurors ranked from 1 to 50, from best to worst. Your goal is to use your limited strikes to eliminate your absolute worst nightmares, while hoping the other side eliminates the people they're most afraid of, who are often your best jurors. It's a delicate dance of subtraction. You don't pick the jury. You are simply left with the 12 people that neither side could find a good enough reason, or have enough strikes, to remove. After hours or sometimes even days of this psychological warfare, a final 12 people, plus a few alternates, are left in the jury box. These are the people who survived the purge. They are a compromise, a mystery. They are the audience you have been given, not the one you chose. The stage has been set, the pieces are in place, and the war for their hearts and minds is about to begin in earnest. Because now you have to stand up, face those 12 strangers, and deliver the most important performance of your life, the opening statement. And on television, that performance is always an explosive, impassioned plea. It's an argument, filled with righteous fury and dramatic accusations, pointing at the defendant, declaring their guilt or passionately proclaiming their innocence. The music swells, the jury is captivated, and in 3 minutes, the lawyer has basically solved the case. And almost every single word of it would get you shut down by a real judge. The single biggest lie TV tells you about the opening statement is that it's an argument. It's not. In fact, arguing is the one thing you are absolutely forbidden from doing. The moment you say, "The defendant is a liar," or "His story makes no sense," you'll hear the other lawyer leap to their feet and shout, "Objection, Your Honor. Counsel is being argumentative." And the judge will say, "Sustained." You'll be told to rephrase, and you'll look like an amateur in front of the 12 people you need to convince. So what is an opening statement? It's not an argument, it's a preview. It's a roadmap. It is a promise. Think of it like a movie trailer. The trailer shows you the key characters, teases the major plot points, and sets the tone. It tells you, this is a story about a hero who must overcome a great evil. It doesn't show you the final battle and then tell you how you should feel about the ending. The opening statement is the trailer. The closing argument, which comes at the very end of the trial, is the film review, where you finally get to argue and tell the jury why your version of the story is the correct one. Let's break down a typical TV opening. Ladies and gentlemen of the jury, look at this man. This cold-blooded monster who, driven by pure greed, snuffed out the life of an innocent victim without a second thought. In a real courtroom, this would be a complete disaster. Let's count the objections. Cold-blooded monster. Objection: argumentative and inflammatory. Driven by pure greed. Objection: counsel is arguing motive. That's for the jury to decide. Snuffed out the life. Objection: inflammatory language. Without a second thought. Objection: counsel can't testify as to the defendant's state of mind. A real lawyer would be lucky to get a single sentence out before being stopped. The real version is far more subtle and far more powerful. A real opening statement sounds more like this. Ladies and gentlemen, this is a case about a choice. The evidence will show that on the night of May 15th, the defendant had a business deal that was failing. You will hear testimony from his accountant that he was facing financial ruin. We will present emails, which you will see with your own eyes, showing he made a final desperate demand for money from the victim. And you will hear from the medical examiner, who will testify that the victim died that same night. We will ask you to follow the evidence, and at the end of this trial, we will ask you to hold him accountable for the choice he made. See the difference? No name-calling, no screaming. It's a calm, confident laying out of the facts you intend to prove. Every sentence is a promise. The evidence will show. You will hear from. We will present. This is the sacred contract of the opening statement. You are making a series of promises to the jury about what they are going to see and hear. And you better be able to deliver. Because the one thing you can be sure of is that your opponent is writing down every single promise you make. And if you fail to deliver on even one of them, they will stand up in their closing argument and say, "Remember when counsel stood here at the beginning of the trial and promised you they would show you the smoking gun? Where was it? They promised you a witness who would say X. Did you hear that? They broke their promise to you. And if they couldn't keep their promise about the evidence, why should you believe their story?" Breaking a promise is one of the fastest ways to lose all credibility with a jury. This is why the opening statement is so strategically critical. It's your first and arguably best chance to frame the entire narrative of the trial. There's a psychological principle called the primacy effect, which states that people tend to remember and be more influenced by the information they receive first. The opening statement is your one shot to harness the power of primacy. You are giving the jury a lens, a filter through which they will process every piece of evidence and every witness testimony for the rest of the trial. Is this a story about a jealous rage, or a story about self-defense? Is this a story about a corporate giant crushing a small business, or a story about a small business that failed to honor a contract? The facts might be the same, but the story, the frame, is everything. The first lawyer to tell a simple, compelling, and believable story often has a massive advantage. To do this, the best trial lawyers develop a theme. A simple, memorable phrase or idea that acts as the central pillar of their entire case. For the prosecution in a drunk driving case, it might be, "This is a case about a risk that became a reality." For the defense in a fraud case, it could be, "This is not a story about a con man. It's a story about a company that failed." This theme is the tagline for your movie. It's the chorus of your song. You introduce it in the opening statement, and you weave it through every stage of the trial. You want that theme to be in the jurors' heads when they walk into the deliberation room. It's the intellectual hook you want them to hang the whole case on. And the delivery is nothing like you see on TV. Lawyers don't typically roam the courtroom, pointing and gesturing wildly. In most federal courts and many state courts, you're required to speak from behind a lectern. Your power doesn't come from theatrics. It comes from control. It comes from making eye contact with the jurors, speaking to them directly and respectfully, not as an actor on a stage but as a credible guide. You are the one person in this confusing new world who is offering them a clear map from point A to point B. Your confidence, your command of the facts, and your belief in your story are what sell it, not shouting. The opening statement is the grand blueprint. You've told the jury what the house is going to look like when you're done. You've promised them a solid foundation, sturdy walls, and a protective roof. But right now it's just a promise on a piece of paper. Now you have to build it. You have to call the witnesses and present the evidence, brick by painful brick, right in front of them. The story has been told. Now it must be proven. And that process starts with your very first witness, in a phase of the trial that TV almost always skips over but is arguably the most important part of the entire case, the direct examination. The entire purpose of direct examination is to have your witness tell your story to the jury. That's it. It's not about the lawyer. It's about the witness. A great trial lawyer on direct examination is practically invisible. They are a guide, a narrator, a gentle hand on the witness's back, leading them through the story they need to tell. The lawyer's job is to ask simple, open-ended questions that allow the witness to be the star. The questions are the famous who, what, where, when, why, and how. Tell me what happened next. Describe what you saw. Explain how that made you feel. The lawyer is just teeing up the ball so the witness can hit it out of the park. Now this brings us to the single biggest rule of trial procedure that nearly every courtroom drama on television gets spectacularly fundamentally wrong. It's a rule so critical that it defines the entire rhythm and structure of a trial. Yet on TV, it's violated in almost every single scene. That rule is the absolute prohibition against asking leading questions during direct examination. So what's a leading question? It's simple. A leading question is one that suggests the answer. It's a question that puts words in the witness's mouth. For example, a TV lawyer examining their own witness might say, "You were terrified when you saw the defendant's car speeding towards you, weren't you?" That is a classic leading question. The lawyer isn't asking what the witness felt. The lawyer is telling the witness what they felt and asking them to agree. The proper, non-leading way to ask that would be a two-step process. What did you see? The witness answers, "I saw the defendant's car speeding towards me." Then the lawyer asks, "How did you feel when you saw that?" And the witness answers, "I was terrified." Do you see the difference? In the first example, the lawyer is the one testifying. In the second, the witness is. The law demands that the testimony comes from the person on the stand, not the person standing at the podium. A leading question signals to the jury that the lawyer doesn't trust the witness to give the right answer on their own. It looks like coaching and it destroys credibility. This is why real direct examination can seem so slow and methodical. It's not a rapid-fire interrogation. It's a painstaking process of building a narrative brick by brick in the minds of the jurors. The lawyer has to establish every single point through the witness's own recollection. Where were you on the morning of June 5th? Who were you with? What time did you arrive? What did you observe? It's a deliberate, almost plotting sequence designed to be clear, logical, and most importantly, believable. The lawyer is building the foundation of their case, and you don't build a strong foundation by cutting corners. And this is where that famous TV line comes in. "Objection, Your Honor." Leading the witness. In a real courtroom, you hear this constantly during direct examination. The second a lawyer tries to spoon-feed an answer to their own witness, the opposing counsel will be on their feet. And 9 times out of 10, the judge will say, "Sustained." Rephrase the question, counselor. It's a fundamental check on the process, ensuring the jury hears the story from the horse's mouth. But here's the crucial detail that TV misses. This rule primarily applies to direct examination. When it's time for cross-examination, when you're questioning the other side's witness, the gloves come off. On cross-examination, leading questions aren't just allowed. They are the primary weapon in a lawyer's arsenal. You want to control the other side's witness, to pin them down, to force them into yes or no answers. You weren't at the office on June 5th, were you? You had a financial motive to lie, isn't that correct? That's the heart of cross-examination. So when you see a TV lawyer asking their own friendly witness a series of aggressive leading questions, you're watching a complete misunderstanding of how a trial actually works. They're playing by cross-examination rules during the direct examination phase, something that would get them shut down by a real judge in seconds. The other thing that gets lost in translation is the sheer amount of preparation that goes into a smooth direct examination. It may look like a simple conversation, but it is anything but. The lawyer has spent dozens of hours with that witness. Not to tell them what to say, that's unethical witness tampering, but to prepare them for the process. They've gone over every topic that will be covered. The lawyer knows what the witness knows and, just as importantly, what they don't know. They've practiced the sequence of questions so the narrative flows logically. The goal is to eliminate surprises. A surprise on direct examination is a catastrophe. If you ask your own witness a question and they give an answer you weren't expecting, it means you have failed catastrophically in your preparation. This is also why the surprise witness trope is so absurd. A lawyer would never, ever call a witness to the stand without having spoken to them extensively beforehand. Putting an unknown quantity on the stand to testify for your side is like handing a loaded gun to a toddler. It is professional malpractice. The entire point of direct examination is control and predictability, building your case with testimony you have vetted, prepared, and can rely on. Part of this meticulous process involves another unglamorous but essential task that TV always skips: laying the foundation. You can't just have a witness talk about a document or identify a piece of evidence out of thin air. You have to establish step by step how they are connected to it. Let's say you want to show the jury a crucial email. You can't just put it on the screen and have the witness say, "Yep, that's the one." First, the lawyer has to go through a formal, almost ritualistic chant. Goes something like this: "I'm showing you what's been marked for identification as Plaintiff's Exhibit 12. Do you recognize it?" "Yes." "Can you tell the jury what it is?" "It's an email I received on July 22nd. Is this a true and accurate copy of the email you received on that date?" "Yes." "Your Honor, we move to admit Plaintiff's Exhibit 12 into evidence." Opposing counsel might object based on authenticity or relevance, but you have to go through those steps for every single piece of physical evidence you want the jury to see. It's the same for a photograph, a weapon, a contract. You have to build the evidentiary bridge, link by link, connecting the item to the witness and the witness to the case. It's the procedural plumbing of a trial. It's not sexy, nobody wants to watch it, but without it, the whole system backs up and nothing works. TV skips it because it's boring, but in the real world, it's the bedrock of proof. But don't mistake methodical for meaningless. While direct examination lacks the high-octane drama of a TV cross-examination, it's where the soul of the case is truly revealed. This is where the jury connects with the people involved. It's where a victim, in their own words, describes what happened to them. It's where an expert witness, patiently and clearly, breaks down a complex scientific concept. It's where a parent can explain the love they have for their child. The real power of direct examination isn't in the lawyer's clever questions. It's in the raw human testimony that those simple questions unlock. A good lawyer knows when to step back, when to be quiet, and when to just ask, "And what happened next?" Letting the witness and their story fill the silence of the courtroom. You build your case piece by piece, witness by witness. You use them to introduce your evidence, to tell your story, to build that logical and emotional connection with the jury. And once you've gotten everything you need from your witness, once they have laid their foundational bricks for your side of the argument, you turn to the judge and say the 5 words that change the entire dynamic of the room. "No further questions, Your Honor." And in that moment, all the calm, all the careful construction, all the gentle guidance comes to an end, because now the other side gets their turn. The opposing lawyer, who has been sitting there silently, taking notes, watching for any crack in the story, slowly rises to their feet. And they get to do what you were forbidden from doing. They get to lead. They get to attack. They get to try and tear down everything you just spent the last hour building. They get to cross-examine. This is the moment the entire trial has been building towards. Cross-examination isn't an interrogation. It's a controlled demolition. The goal isn't to get the witness to tell a new story. The goal is to prove to the jury that the story they just heard is a lie, a misremembrance, or a carefully constructed fantasy. It's the most misunderstood, most mythologized, and most brutally effective part of any trial. And the first thing we have to do is throw out the single biggest lie Hollywood ever sold us. The Perry Mason moment. You've seen it 1,000 times. The heroic lawyer, pacing before the witness stand, voice rising with righteous fury. He points a finger. "You say you were at the library, but I have a witness who saw you at the docks. You hated the victim, didn't you? You hated him for stealing your promotion. You pulled the trigger." And the witness, sweating under the lights, suddenly cracks. Their face crumples, tears stream down, and they sob, "Yes, yes, I did it. I'm glad he's dead." The gallery gasps. The judge bangs the gavel. Case closed. It is magnificent television. And it is pure, unadulterated fiction. It has never happened. It will never happen. And here's why. The real work of a trial lawyer isn't done in the courtroom. It's done in the months, sometimes years, leading up to it in a process called discovery. During discovery, both sides are legally required to show each other almost their entire hand. They exchange witness lists, police reports, expert findings, documents, emails, photographs, everything. There are no surprise witnesses jumping out from the back of the courtroom. There is no secret case-breaking document pulled from a briefcase for the first time. More importantly, that witness on the stand has been deposed. For hours, sometimes for days. They sat in a conference room with the opposing lawyer, a court reporter, and their own attorney, and they answered every conceivable question under oath. That lawyer on cross-examination already knows what the witness is going to say because they've already asked them. They have a transcript, hundreds of pages thick, of the witness's previous sworn testimony. This leads to the first and most sacred rule of cross-examination, a rule so fundamental that breaking it is considered a form of professional malpractice. Never, ever ask a question you don't already know the answer to. Asking an open-ended question on cross is like handing a loaded gun to your enemy. A question like, "So why were you angry at your boss?" doesn't corner the witness, it liberates them. It gives them a platform to retell their story, to explain their side, to gain sympathy from the jury. Gives them control. And cross-examination is all about control. A real lawyer never gives it away. Instead, a real cross-examination is a series of statements disguised as questions, all designed to be answered with a simple yes or no. This is the second rule. Use only leading questions. On direct examination, you couldn't lead. Now it's the only thing you're allowed to do. You're not asking for information. You are providing it. You are the one testifying. The witness is merely there to affirm the facts you are presenting to the jury. Let's see it in action. A TV lawyer might ask, "What was your relationship with the defendant like?" That's a terrible question. It lets the witness say, "Oh, we were the best of friends, we never argued. This is all a terrible misunderstanding." A real trial lawyer would do this. "You worked for Mr. Smith for 5 years, correct?" "Yes." "And in those 5 years you never received a promotion, did you?" "No." "You asked for a promotion in May of last year, didn't you?" "Yes." "And Mr. Smith denied that request?" "Yes." "And 2 weeks later you sent him an email, didn't you?" "I believe so." "An email in which you wrote, 'You will regret this,' correct?" "Yes." See the difference? There's no room for a story. No room for explanation. It's just a series of undeniable facts. Each yes is another brick in the wall the lawyer is building around the witness. The lawyer isn't yelling. They're not even being aggressive. They're being methodical, surgical. They are leading the jury step by step to a conclusion that they want them to reach on their own. The true goal of cross-examination isn't to get a confession. It's a legal concept called impeachment. You are impeaching the witness's credibility. You are showing the jury, piece by piece, that this person's testimony cannot be trusted. And there are several ways to do it. The most common is with prior inconsistent statements. This is where that deposition transcript becomes a weapon. The lawyer will let the witness testify on direct, telling their story. Then on cross they'll zero in. "Mr. Jones, a moment ago, you testified that you saw a red car speeding away from the scene, is that right?" "Yes, that's what I saw." The lawyer will then walk slowly over to their table, pick up a thick, bound transcript and approach the witness. "Mr. Jones, do you remember giving a deposition in my office on March 12th? "Yes." "And you were under oath that day, same as you are today?" "Yes." "And you swore to tell the truth, the whole truth and nothing but the truth?" "Yes." "I'd like to direct your attention to page 84, line 12. I asked you, what color was the car? Do you see your answer there?" The witness looks. He knows what's coming. "Could you please read your answer aloud for the jury?" He mumbles. "I said it was a blue car." "I'm sorry, I couldn't hear you. Could you speak up?" "I said it was blue." The lawyer doesn't shout. "Aha, you're a liar." They don't have to. They just pause. They let the silence hang in the air. They've just shown the jury, with the witness's own words, that he has told 2 different stories under oath. He lied then or he's lying now. Either way, his credibility is shot. Why should the jury believe anything else he has to say? Another way to impeach is to show bias. Is the witness the defendant's mother? Is he a business partner who stands to gain if the defendant is acquitted? Is he an expert witness being paid $50,000 for his testimony? You're not saying he's lying. You're just giving the jury a very powerful reason why he might be. Or you can attack the witness's ability to perceive. It was after midnight, correct? And it was raining? The streetlights on that corner were broken, weren't they? And you weren't wearing your glasses that night, were you, sir? Again, you're not calling him a liar. You're just painting a picture for the jury that makes it impossible for him to have seen what he says he saw. This is the real art of the courtroom. It's a slow, patient, methodical dismantling. It's a death by 1,000 cuts. The lawyer controls the tempo, the rhythm, the focus. They might use a rapid-fire series of questions to build momentum, to get the witness used to saying yes, 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 before slipping in the one critical question they want to land. Then they'll stop, slow down, and let the weight of that answer sink in with the jury. The performance you see on TV, the shouting, the pointing, the dramatic revelations, it's not just fake, it would be ineffective. Juries don't like bullies. They resent a lawyer who badgers a witness. But they respond to a calm, logical, surgical dissection of a story. They respond to being shown, not told, that a witness is unreliable. The lawyer's goal isn't to find the truth. Their goal is to win. And on cross-examination, winning doesn't mean a dramatic confession. It means planting one single powerful seed of reasonable doubt. Because in the end, that's all it takes. But the fight over the witness isn't over. After the cross-examining lawyer has done their best to tear the witness down, the lawyer who called them in the first place gets another chance to put the pieces back together. They get one last opportunity to salvage their witness's credibility in a process called redirect examination. And that's a whole new game with its own set of traps. Redirect examination is where a good lawyer plays chess while the TV lawyer is still playing checkers. It's not about a dramatic second act. It's about subtle surgical repair. The trap of redirect is that it's incredibly narrow. The golden rule is you can only ask questions about subjects that were brought up during the cross-examination. You don't get to ask about that one brilliant thing you forgot during your first round. If the opposing lawyer didn't open the door, it stays shut. This is a rule Hollywood gleefully ignores. On TV, a redirect is often a second chance for a grand monologue, where the lawyer asks a completely new question that cracks the whole case open. In reality, a judge would shut that down so fast your head would spin. The real purpose of redirect is to clean up the mess the opposing counsel just tried to make. Let's go back to our eyewitness who saw the getaway car. On direct examination, your lawyer had her testify. "I saw the defendant's blue sedan speeding away." Simple, effective. Then, on cross-examination, the defense lawyer pounces. They pull out her initial police report. "Ma'am, you testified today that the car was a blue sedan. But isn't it true that on the night of the incident, you told the police it was a dark-colored vehicle? Which is it? Were you unsure then? Or are you unsure now?" The witness stammers. "Well, it was dark." The lawyer cuts her off. "And you weren't wearing your prescription glasses that night, were you?" "No, but..." "Thank you, no further questions." The jury is now thinking this witness is unreliable. Her testimony is tainted. Now comes the redirect. Your lawyer stands up, calm and collected. They're not going to ask a new question. They're going to use the defense lawyer's own questions as a springboard. "Ma'am, the defense attorney asked you about telling the officer the car was a dark-colored vehicle. Could you please explain to the jury why you used those words?" Now the witness can finally give the context she was denied. "Yes, it was a very dark navy blue, almost black under the streetlights. I said dark-colored to the officer to be safe, but in my mind it was clearly blue." The lawyer continues. "And counsel also pointed out you weren't wearing your glasses. What do you need glasses for?" The witness smiles slightly. "For reading. My distance vision is 20/20. Boom. In 2 questions, the damage is not only repaired, it's reversed. The witness's credibility is restored. And the defense lawyer now looks like they were trying to mislead the jury with cheap tricks. That is the art of redirect. It's not a bombshell. It's a quiet, precise defusing of the bomb the other side just planted. It's about giving your witness the chance to explain the yes or no answers they were forced to give. It's the final brushstroke that brings the picture back into focus. And once all the witnesses have been called, cross-examined and redirected, we arrive at the part of the trial that television has transformed into an almost mythical event, the closing argument. On screen, this is the moment. The music swells. The lawyer, often sweating and impassioned, paces before the jury box, delivering a speech for the ages. They'll appeal to morality, to justice, to the jurors' very souls. They might even reveal a shocking new interpretation of events that no one had considered before. The jury is visibly moved, some even to tears. And based on this one magnificent performance, the verdict is decided. This is, to put it mildly, a fantasy. The single most important rule of a closing argument, the one that Hollywood breaks in nearly every movie, is this: you cannot introduce new evidence. You cannot even mention a fact that wasn't entered into evidence. Your entire argument must be built, brick by brick, from the testimony and exhibits the jury has already seen and heard. A closing argument is not a sermon. It's a summary. It is the lawyer's last chance to act as the jury's guide, to walk them back through the maze of the trial, and show them how all the pieces connect to form the picture they've been painting all along. If a lawyer even tries to mention something new, the other lawyer will be on their feet instantly, shouting objection. Counsel is arguing facts, not in evidence. And the judge will sustain that objection every single time, often with a stern warning to the offending lawyer in front of the jury, which completely shatters their credibility. The entire purpose is to frame the narrative using only the approved materials. Think of it like a cooking competition where all the ingredients have already been chosen. The closing argument is the chef explaining to the judges how they combine those specific ingredients to create their dish. They can't suddenly pull a secret, exotic spice out of their pocket. A real closing argument is far more methodical and, frankly, less cinematic. It's structured. The lawyer will start by reminding the jury of the standard of proof, beyond a reasonable doubt in a criminal case. Then, they will literally walk through their key points. You heard from Officer Smith, who testified that he found the muddy boots in the defendant's closet. And then you saw Exhibit 12, the lab report, which confirmed the soil on those boots was a chemical match for the soil at the crime scene. Then you heard the defendant's alibi witness claim the defendant was home all night. But remember the text messages, Exhibit 23, where the defendant told his friend he was going out to take care of business at the exact time of the crime. It's about connecting the dots. It's logic, not just emotion. Yes, passion is a tool. A lawyer wants to connect with the jury on a human level, but that passion must be anchored to the evidence. An emotional appeal without factual support is just hot air, and most juries see right through it. The goal is to empower the jury, to give them a clear, logical roadmap so that when they go back into the deliberation room, they can argue your case for you. You're arming them with the facts, organized into a coherent story. And that brings us to the final black box of the American legal system: the jury room. TV loves to portray jury deliberation as a hotbed of conflict and drama. A single principal juror holds out against 11 angry ones, slowly winning them over with brilliant insights and appeals to conscience, like in the classic film 12 Angry Men. While disagreements certainly happen, the reality of deliberation is governed by a set of incredibly strict, formal rules that television almost completely ignores. Before the jury is even allowed to talk to each other, the judge reads them what are called jury instructions. This can take an hour or more. It is a dense, legalistic document that explains the exact law that applies to the case. It defines every single element of the crime the prosecution must prove. It explains complex concepts like reasonable doubt or proximate cause. These instructions are not suggestions. They are the binding rules of the game. The jury's job isn't to decide what they feel is right. Their job is to take the facts they heard and see if they fit into the legal framework the judge has given them. This is arguably the single most important part of the trial, and it's the part that is almost always left on the cutting room floor. Once in the deliberation room, the jurors are completely sealed off. Their first task is usually to elect a foreperson. Unlike in the movies, the foreperson isn't the boss or the main character. They are an administrator. Their job is to keep the discussion orderly, to make sure everyone is heard, and to handle the formal communications with the court, like passing notes to the judge with questions or announcing that a verdict has been reached. And the most sacred rule of all is that they can only consider the evidence presented in the courtroom. They are explicitly forbidden from doing any outside research. No Googling the defendant. No looking up legal terms. No visiting the crime scene on their own. No asking a lawyer friend for their opinion. A juror who does this can cause a mistrial, throwing out weeks or months of work and costing taxpayers hundreds of thousands of dollars. In the digital age, this has become one of the biggest challenges for courts, with judges constantly reminding jurors to stay off their phones and off the internet. It's a fundamental principle. The verdict must be based solely on the shared set of facts that both sides had a chance to challenge and examine in open court. It's this rigid, controlled process that leads to the most dramatic moment of all, the verdict. And what happens after that verdict is read is a whole other world of Hollywood myth. The camera pushes in on the jury foreman, a single bead of sweat on his brow. The judge's voice echoes, "On the charge of murder in the first degree, how do you find the defendant?" The foreman unfolds a piece of paper, his hand trembling. He looks at the defendant, then at the victim's family. He takes a deep breath and says the single word that will change everything. The gallery erupts. Someone screams. The defendant either collapses in tears of relief or lunges in a fit of rage, being tackled by bailiffs. The lawyer claps his client on the back, a triumphant hero, or slams his briefcase shut in disgust. Cut to commercial. This is the moment we've been conditioned to expect. The emotional climax. The definitive end. And it is almost entirely a work of fiction. In a real American courtroom, the reading of the verdict is one of the most solemn, controlled, and eerily quiet moments in the entire legal process. There are no outbursts. The judge will have sternly warned everyone in the gallery, families, reporters, the public, that any reaction, any gasp, any sound at all will result in them being immediately removed and possibly held in contempt of court. The tension is thick enough to taste, but it is a silent tension. The jury foreman or foreperson stands, but they don't make a dramatic speech. They often just hand the verdict form to the bailiff, who hands it to the judge. The judge reviews it to make sure it's filled out correctly. There's no suspenseful unfolding of a tiny piece of paper. The judge then hands it to the clerk to be read aloud. The clerk reads the finding on each count in a steady, almost monotone voice. On the charge of murder in the first degree, we the jury find the defendant not guilty. And here we hit the single most misunderstood concept in the entire American justice system. A myth so pervasive that it fundamentally distorts how we see every trial on television. The verdict is never innocent. It is guilty or not guilty. This isn't just semantics. It's the entire philosophical bedrock of our legal system. A not guilty verdict does not mean the jury believes the defendant is factually innocent. It doesn't mean they think the person didn't do it. It means one thing and one thing only. The government, with all of its vast resources, failed to meet its burden of proof. It failed to prove guilt beyond a reasonable doubt. The defense's job isn't to prove innocence. The defendant doesn't have to prove they were somewhere else. They don't have to prove an alternate theory. They can sit there and say nothing at all. The entire burden is on the prosecution. A not guilty verdict is the jury saying to the government, "You didn't convince us. You didn't close the deal. You left a reasonable doubt in our minds." It's a judgment on the strength of the prosecution's case, not a declaration of the defendant's purity. That's why O.J. Simpson could be found not guilty in his criminal trial but later be found liable for the same deaths in a civil trial. The burden of proof in the civil trial was much lower, a preponderance of the evidence, meaning just more likely than not. The criminal standard is the highest in our legal system for a reason. The state is trying to take away someone's liberty, or even their life. The jury has to be sure. Innocent is a moral and factual state. Not guilty is a legal one. And what happens in the seconds after that legal state is declared? If the verdict is not guilty, there isn't a massive celebration. The defense lawyer will likely put a hand on their client's arm, whispering to them to remain calm and show no reaction. There is still a grieving family on the other side of the room. Professionalism and decorum are paramount. The client is then processed out, which can still take hours. They don't just walk out the front door into a sea of flashing cameras. If the verdict is guilty, the reaction is even more stark. The defendant's life changes in an instant. Depending on the charge, the judge might say, "The defendant is remanded into custody." At that moment, deputies will step forward, place the person in handcuffs, and lead them away through a side door. There's no time for a tearful goodbye with family. There's no final, defiant speech to the prosecutor. The machine of the state takes over, and it is swift and impersonal. The lawyer's job is now damage control, preparing for the next phase. Because here's the next giant myth. The verdict is not the end. In a criminal case, it's not even the end of the trial court proceedings. TV loves to merge the verdict and the sentence. Guilty. I sentence you to 25 years to life. Take him away. In reality, sentencing is a completely separate hearing, often held weeks or even months after the verdict. During that time, a probation department will conduct what's called a pre-sentence investigation, or PSI. They create a massive report that details every aspect of the convicted person's life. Their childhood, their education, their employment history, their family situation, their prior criminal record, their psychological state. Both the prosecution and the defense will submit sentencing memos to the judge, arguing for a harsh or a lenient sentence. At the sentencing hearing, victims or their families may give powerful, emotional impact statements. The defendant may also speak on their own behalf. Only then, after considering all of this, will the judge impose a sentence. It's a deliberate, drawn-out, and often agonizing process, not a spontaneous declaration from the bench. But even that isn't the end of the road. Let's say your lawyer loses. The jury says guilty, and the judge imposes a sentence you feel is unfair. On TV, this is where the credits roll. In real life, this is where the lawyer's real work can begin. The appeal. And an appeal is absolutely not what you think it is. It is not a new trial. You don't get to bring in new evidence you found after the fact. You don't get to put on new witnesses. An appeal is not about relitigating the facts. It is not a chance to convince a new jury that you're innocent. An appeal is a highly technical academic process where you argue to a higher court, an appellate court, that the trial judge made a serious legal error during your original trial. Your appellate lawyer becomes an archaeologist, sifting through thousands of pages of trial transcripts, looking for mistakes. Did the judge improperly allow certain evidence to be shown to the jury? Did they give the jury incorrect legal instructions? Did the prosecutor engage in misconduct that the judge failed to stop? Was your original lawyer so incompetent that you were denied your constitutional right to effective counsel? You are not arguing your innocence. You are arguing that your trial was legally unfair. It's like asking the referee's boss to review the game tape, not to replay the game. You're pointing to a specific moment and saying, "That was a bad call, and it changed the outcome of the game." It is a slow, painstaking, and incredibly difficult process. The vast majority of criminal appeals fail, but it's a critical safeguard, a recognition that the system being run by human beings is not infallible. And what about civil cases? You win your lawsuit against a big corporation. The jury awards you $10 million. The lawyer on Suits would be popping champagne and handing you a check. The reality? You've just won a piece of paper. A very important piece of paper called a judgment, but a piece of paper nonetheless. Now you have to collect it. Winning the judgment and collecting the money are two completely different battles. The defendant can, and often will, fight you every step of the way. They can appeal the verdict, tying you up in court for years more. They can try to hide assets, moving money to offshore accounts. They might declare bankruptcy, which could wipe out your judgment entirely. You, the winner, now have to become a detective and a creditor. Your lawyer will have to file liens on property, garnish bank accounts, and haul the defendant back into court to force them to disclose their assets. Many huge, headline-grabbing verdicts are never paid in full. They get reduced on appeal or settled for a fraction of the original amount, just to avoid decades of more legal fighting. Winning the verdict in a civil case is like winning the Super Bowl. Collecting the judgment is like trying to get the entire opposing team to actually hand over the trophy. It's a whole new game, and it's a brutal one. The win in court is almost never a clean final victory. It's the end of one chapter and the violent, uncertain beginning of the next.